My name is Graham Penn. I'm Professor of International Finance Law here at UCL and Director of the MLF program, which I've spent a considerable amount of time curating. So I'm very excited about sharing that with you. I should try to capture precisely what this program is right at the start. I hope I'm going to be able to do that. So this is an innovative program, and it's a transdisciplinary program, an executive master's course that is looking to develop your critical thinking in both finance and law. So it's trying to provide you with a deep understanding of the legal, economic, and regulatory drivers that underpin complex corporate and finance transactions in today's corporate and finance world. And we're trying to do something, I think, quite unique in this course. This is one of a handful of courses that are offered at leading universities throughout the world. But I think this really is a unique course in that not only are we going to be teaching you the underlying theory that underpins these transactions, the economic and finance theory on the one hand and the legal theory on the other, but we're going to look to be bringing those theories together and explain to you how one intersects with the other and actually is applied in practice. And it's that third component in particular, I think, that is unique. So there is a practical learning pathway to this particular course in the form of the placements and the deal simulations, which I'll come back to talk about in more detail in a few moments, which actually will require you to apply your learning in real world situations, in real world transactions that are looking at the interaction between law and finance, which I think is really exciting. And what this will do is prepare you for a career in either law or finance in the market today. So I think what we're hoping to do is not only give you the fundamental tools that will enable you to operate in the market, but actually bring you up to date with the way the market is operating today, what some of the drivers are. So you're going to be going into the workplace with a good understanding of that market. We can just roll these slides on, please, Rafa. And again, if I may. Yeah, so that previous slide was just talking about the way the course is delivered between the various departments. This is obviously a transdisciplinary degree, and it's taught by the Faculty of Laws, people from the Department of Economics here, but critically from the School of Management that is based in Canary Wharf, where the finance and economic side will be delivered. These are both market leading departments, and you'll be taught by some of the top academics and practitioners really throughout the world. If we can roll back to there we are. This gives you a sense of people that are involved in both of those faculties that will be critically involved in the course. And if I run through them, you get a sense of how you'll get this mix of the academic principles and the practical understanding of those principles. So just running through this team, Chris Hale is a senior partner at Travis Smith Braithwaite, well, was for most of his life. He's recently stepped down and is on the faculty here at UCL. He is as steeped in the private equity world as you could possibly imagine. And UCL is offering for the first time this year as part of the MLF, I think probably the only dedicated private equity course that is offered anywhere in the UK. I mean, whether there's a course offered in the world, I don't know, but certainly the only one that is offered in the UK. And we will continue to offer that next year. Jonathan Haynes is another member of the laws faculty here, spent most of his career as a partner at one of the leading corporate firms in the UK, Ashurst. He's a derivatives and finance lawyer, and he will be playing a major role in the core corporate finance course and other options that you'll be able to take. That's a very young version of me going along next. I'm obviously a full-time academic here at UCL, but I've spent the vast majority of my career, nearly 35 years, working in private practice with one of the world's largest law firms, where I co-headed the global finance practice, and I did that in conjunction with my teaching here at UCL. So for the entire time of my life, actually professional life, I've both taught and practiced complex structured finance law, and I continue to do that. Alex Gorbenko is an economist who is based in Canary Wharf, part of our School of Management, leading economist, leading financial economist, and he will be teaching one of the core courses on the economic side, looking at the economic aspects of some key deals that take place in the market. Alex Wood, another member of the faculty who is a practitioner with McDermott, leading practitioner in the field of corporate restructuring, which is obviously a key part of the course. So complex restructurings in the finance world, he will be leading the lectures on that, and supported by Philip Gavin, another full-time academic here at UCL, who will be working primarily together with Alex Wood on the restructuring side. Pedro, who is the final picture on here, is another corporate finance lawyer, particularly focusing on ESG-related developments at the moment. Pedro has worked in industry at places like the World Bank and is now full-time here at UCL, but continues to do consultancy work in the market. So that gives you a sense of the other people involved, but this is the core team. And I hope you get a sense from what I've said about that core team that in each case, not only are these leading academics that have written some of the leading textbooks in the field. For example, Chris Hale has recently edited the leading textbook in private equity, but also people that have enormous practical experience in the market as well. If we can move on, please, Rafa. This slide gives you a sense of the way we structure the course. And again, I think there's some very unique features about this. So we're very conscious that the cohort that we have is a mixed cohort with economists, finance experts who have read finance or economics related undergraduate degrees or perhaps have experience in that area on the one hand, and lawyers on the other, and we teach you together. And so what we do prior to the course formally starting at the end of September, beginning of October, is run some pre-sessional courses, which we encourage everyone to take actually, but the pre-sessional courses are fundamentally bringing the economist up to date with the legal issues that they will need to be aware of before they start the course, and conversely bring the lawyers up to date with the economic and finance issues and background principles that they'll need in order to be comfortable with the economics and finance courses. And part of that will be online before you start, and then you will come effectively a week early before the main teaching of the MLF starts, and there will be in-person teaching for the second part of those pre-sessionals. Once we start the term proper, so to speak, at the end of September next year, we then have core courses that are offered throughout the entire year, both on the economics and financial drivers. So in term one, that's the economic foundations of regulation and governance and investments and asset management, and a laws course that is running for the entire year. So the theory and practice of the law of corporate finance runs not only for term one, but also for term two. You see that in term two, the economics course moves from economic foundations and investment to corporate transactions and restructuring, which builds on the fundamental economic principles that you will have studied in the first term. The laws course, the laws core course continues to apply that. So although the laws course focuses more on the analysis of the legal issues, we look at cases and statutes and how that is applied, but we are looking at the underlying economic theory as well. So we'll be looking at the attitude and the approach that is taken in the courts in principally the UK, but we also look at Delaware as well, which is the principal corporate jurisdiction in the United States. Look at the way in which the courts in those jurisdictions apply economic theory to their legal analysis. In addition to those core courses, we have optional courses, which I'll come back to in a moment. But all of that is then applied in the summer term. So this is a course that runs throughout the entire year, but we have effectively two 10-week terms, term one and term two, where you have the underlying teaching, where you're looking at the underlying theory and the analysis of the issues. And then in the summer term, we have this combination of work placements and deal simulations, which give you the opportunity to experience the application of the principles that you've learned during the courses in practice. We can move on, please, Rafa. If I can talk a little bit about the optional modules which we have listed here, I think the two that are stand out are on the laws pathway. So you will choose one of these options. There's a lot of teaching on the core courses. So we give you an opportunity to select one additional option. And most people this year, we're running the course this year, as you know, have chosen either private equity or corporate insolvency and restructuring, which fit very nicely indeed into the sort of typical expertise that people are looking for when they come on the course. So I think most people are looking for expertise both in the economics and law of public and private corporate world. So whether that's private equity, corporate M&A, the financial aspects of those markets, so the financing of private equity acquisitions, the financing of main public acquisitions, and then potentially complex restructurings in those worlds. We offer other options as well, but as I say, I think the most obvious ones to choose are private equity and corporate insolvency. On the economics and finance side, we have a broader range which are listed there, and you can take up to 2 of those courses. If we can move on, please, Rafa. If I can talk next about the applied learning pathways, then the deal simulations have been developed specifically for the MLF. These are not just case studies. These are deal simulations that have been developed with leading international law firms, some of the largest law firms in the world, and they will be delivered at the premises of those firms. And not only will they be delivered by the law firms who have worked on these underlying transactions, because the simulations will be based on real transactions that have been worked on in the market. They'll also be supported by other parties that have been involved in those transactions. So we'll be looking at the underlying drivers for the transactions. You know, what were the economics? What were the regulatory issues? What was it that motivated the parties to enter into those transactions? And what implications did those objectives, those drivers have for the way that the transaction was structured, the way that the transaction was documented, the way that the transactions were negotiated? So we're looking to give you a really holistic understanding of these the transactions. And to give you a sense of what they will cover a public type acquisition, a private type acquisition, a complex financing of one of those transactions, and a complex restructuring. Each of the deal simulations will be preceded with quite a bit of instruction. The academic that leads the deal simulation will take you through the documentation, will give you a sense of the underlying economic principles or legal issues that are likely to arise. You will then go away and experience the simulation. You'll be taken through the simulation by experienced practitioners who've worked on the deal, and then come back, and there'll be an opportunity for a group presentation and group work in relation to each of the simulations. The simulations will run for a period of between 7 to 10 days during June and July at the end of the course. So the expectation is that you will be experienced enough by the time you finish the course to really get to grips with the issues that arise. The placements are similar. Again, these are bespoke placements that have been developed with a number of leading international and finance firms. We'll talk about those in a moment. Specifically for the MLF, most firms that offer placements like this are much, much shorter. There will be placements that will run for a week, 2 weeks, 3 weeks at most. These will be placements that will run for 2 months, and there will be placements that will have an expectation of you getting involved working on the transactions that are being dealt with at the relevant law or finance firm that you're placed with. We expect the vast majority of students that come on the MLF program to take one of those 2 learning pathways. because they have been developed, as I indicated at the beginning of this presentation, to give students the opportunity to apply in practice what they've learned during the course. And it's really, I think, important that people have that opportunity to do that. So when you finish the course, you not only have the underlying theory that underpins the markets, but you understand how that theory is applied in the real world. There are a small number of students who will come on the course with an intention to follow a different career trajectory, possibly stay in academia. And we have kept open an opportunity for people to embark upon an independent research essay, 9,000 word piece of independent research that they will be able to deliver, recognizing that that type of pathway will be important to people that are pursuing a career in academia. But again, the distinguishing feature of that independent research essay is that not only will it require you to deliver a thoughtful and independent piece of research, but it will also require that piece of research to deliver an intersection between law and finance. We'll be expecting you to be covering a topic that will give you an opportunity to analyze the way in which underlying economic drivers interplay with law in the corporate and financial markets. We can move on, please, Rafa. This slide is just giving you a sense of the firms with which we have developed partnerships for this year. So you can see from that list, these are some of the largest and most well-known global firms, finance and law firms in the market. I don't think any of you will be disappointed by any of the names on that list. I think we can move on, Rafa. Yeah, I think I've talked enough about deal simulations. I'll keep this short. We can move on again. And placements, if we can move on, just a bit more detail. And the independent research essay. Yeah, just dwell on this, if I may, for a couple of moments. So these are the professional skills. So we're looking to give you a unique mix of theory and practice. I think I've made that clear. But the magic, if I can call it that, is then giving you an opportunity to apply that in the deal simulations and or placements, which will be the third component of the course. So you will actually leave the course having not only a good understanding of what the relevant issues in the market are, which I like to think most economists or lawyers would have if they were pursuing any postgraduate course, but critically here, you will then understand how they intersect, how they interplay with each other in the market, how one drives the other, how one reacts to the other, which I think is a very unique skill set. But then in addition to that, we'll give you the ability to apply that knowledge. I think that gives me an opportunity to introduce Maria, and Maria will talk to you about the careers aspect of the program.
Yes, thank you, Graham. So my name is Marie. I am the dedicated careers consultant for the MLF program. This means students on the program get dedicated support from me throughout the whole program. This means there's guidance work I support students from the beginning throughout the whole program with their career decisions, their applications, making the right decisions on a number of different ways. One is one-to-one appointments. These can be guidance appointments, but they're also application advice and mock interviews. So for any of our students that get any job interviews, there's dedicated support for that. There's also a number of career workshops I run with students. These rank from being market specific, both keeping the law and the finance side in mind, CV support, application support, interview support, specific workshops on networking, both in general and specific methods for networking, as well as preparing for the placement, or also how to get the best out of the deal simulations from a careers point of view. I think there was a question popped up. Students do one of the three options, and there's dedicated support for the placement applications, as we do have a recruitment process for those, and students do get supported throughout the whole process to give everybody a fair and best chance to secure the placement they want. Yeah, I think that's it for me. I'm dedicated to this program as a career support, which in my knowledge is unique in UCL, but also unique for other universities to have a careers consultant working long term with a cohort and supporting those specific needs. Graham, back to you.
If I can just, yeah,
Yes.
if I can just add to that, I think Maria is underplaying the quality of what she is offering, as she always does. Maria has been with me throughout the process of developing these relationships with the firms, and has therefore a really good understanding of what the firms are looking for in the market. So that only goes to the actual placement process itself, if that's what you're interested in, but it's much broader. So Marie now has, a really good understanding of what finance and law firms are looking for in terms of their prospective recruits in this market. So whether you're doing the placements or not, I mean, obviously, if you are doing the placements, Marie is going to give you a lot of guidance in making the applications, if that's the pathway that you want to follow. But even for those that are not, and the deal simulations are an extremely attractive alternative, Maria is there to support you in your decision and career path choices that you're thinking of going into the legal and financial world as well. So as Maria has just said, that's a pretty unique offering. I'm not aware of any other university course that offers dedicated career support for one particular course. Anyway, thank you, Marie. We should move on.
Thank you, Graham.
So what I'm now going to try to do is achieve the impossible. As you can probably already tell, listening to me, I'm super excited not only about the program, but about the subject matter that we deliver in the program, which is what I've been working in all my life. I'm going to try to give you in 10 or 15 minutes a sense of how law and economics intersect and how we actually teach it. And forgive me, I appreciate the subject matter I'm going to be covering is probably new to most of you. So I'm not expecting you in 10 or 15 minutes to become experts in the field. I'm just trying to give you a sense of the approach we take. So anyway, let's move on, Rafa. Yeah, we can carry on moving on, please, to the next diagram. And again. Yeah. So what I'm going to talk about first, I'm going to talk about three things if I've got time. I'm going to be talking about the cost of money. I'm going to be talking about the world of private equity because it's just so important in the market today. And if I've got time, I'm going to be talking a little bit about leverage. So this first topic I'm choosing simply because it's just been so high profile in the market for years. It's one that some of you may become aware of. So that number is 450 trillion. If you don't know, I confess, when I first saw it, I didn't know what it was. This is 12, 13 years ago. And it is the number that represents all of the contracts in the world that were ultimately calculated by reference to LIBOR. LIBOR is the London Interbank Offered Rate, and it's the rate that was used to calculate the cost of money for many, many years. If we can move on to the next diagram, please. Hopefully some of you will be familiar with LIBOR, or at least have heard of it. If you've read newspapers at all, any quality newspapers in the past 4 or 5 years, you will be aware of it because it's come up time and time again. It's probably been one of the most important commercial issues. And it was an issue because there was a huge scandal. LIBOR was manipulated by traders in the market and needed to be replaced. The problem was that it was just such an important calculation. It was such an important benchmark. It's called a benchmark in terms of the calculation. Replacing it was very, very challenging indeed. and it has been replaced. And it is a fact. I've worked with many lawyers and many finance people in the market. It's something that happened with people not really understanding what it was. And I can look over my career over 35 years, and I can probably count on one hand the number of people that I ever worked with that ever really understood the underlying principles upon which LIBOR was based. And this course will do that, not only in relation to LIBOR, obviously, but in relation to what it was replaced by. And I'm going to try to give you a little bit of a flavor of that. So if we can move on, please. And let's move on again and look at the actual diagrams. Yeah, so the underlying principle from where LIBOR was developed was an incredibly simple one, and it was almost a magical fix for a problem that arose in the late 1960s. So historically, the way that banks in the market, banks historically dominated the lending markets. They don't anymore, we'll come back to that, but they did historically. And the way that banks historically funded their business was quite simple. They took deposits from their customers, they paid depositors a level of interest on those deposits, and they used those deposits to make loans to customers, in particular corporate borrowers, again, who they charged interest, and the profit the bank made was on the difference between what they were charging the corporate borrower and what they were having to pay their depositors. That changed quite dramatically in the late 1960s, early 1970s, and if we can go to the next diagram, because loans became too large for any one bank to make available. This was the birth, if you like, of what is now known as the syndicated loan market, which is very much the dominant loan market in the market today. And the challenge that arose when we moved from bilateral loans, where one bank was making a loan to a borrower, to multiple banks, a syndicated loan, and again, there's no reason why you should know any of this, but a syndicated loan, as its name suggests, is a loan that is made available by a collection of banks. This is an incredibly simple example with 5 banks making a loan available to a borrower. In most syndicated loans, there are many, many more than 5 banks. But the challenge, I'm not here to teach you about syndicated loans today. I'm just trying to explain how you price these loans. The challenge was that these particular lenders came from lots of different jurisdictions, from lots of different finances, from lots of different situations in terms of their relationships with their borrowers. So their underlying cost of money, the cost of each of these banks having to pay their depositors would be different, obviously, depending upon the bank, depending upon the location, etc. A syndicated loan was never intended to then deliver to the borrower loans where the underlying loans were priced in a different way. What a syndicated loan was intended to do, it was developed by a Greek banker called Zombonakis, was facilitate multiple lenders making what was effectively a single loan available to a borrower. And critically, a loan that was priced at a single rate of interest. And the way that it did that was basically provide a mechanism whereby each of the banks, in this particular case, the 5 banks, would confirm the cost to them of financing the loan. And this then developed the interbank market. They did that by effectively going out and getting quotations from the market. And if we assume we're looking at Bank 5 for these purposes, so Bank 5 would be going out into the market, would be speaking to another bank, and would be confirming with that other bank what it would cost Bank 5 to borrow 100 million from the bank. And what that would then do is give that bank the cost of funding its particular portion of the loan. Once all of those quotes had come in this particular case, let's assume that there were 5 quotes because there were 5 banks. Each of those quotes, the quotes that had been given to each of the banks, would then be aggregated and a single cost of finance would be identified. That was then used to build what became LIBOR. So LIBOR moved obviously from this principle of individual banks getting quotes to one where the quotes were obtained initially by the British Bankers Association, a trade association that was based in London, and then beyond that to something called ICE. It doesn't matter, but there was an administrator, if you like, of the system. Which would be the recipient of quotations from banks in the market that would then reflect the cost of money in the market at a particular time. And that became known as the London interbank offered rate. It was a single rate. That was not the full cost. It was obviously passed on to the borrower because all that rate did was reflect the underlying cost of lending. There was no profit element in that. So in the loan agreement, we have the underlying cost. Historically, that was LIBOR plus a margin that is applied to LIBOR. And it was the margin that was meant to reflect the credit risk that the banks were taking in making the loan available to the corporate borrower and would reflect the profit that they would be charging to take that risk. So interest was always at least two components. Actually, today it's three because of regulatory costs as well, but we don't need to talk about that today. But the core of the calculation is the market cost of money. If we can just move on to the next slide, please, Rafa. What this slide is trying to do is explain to you that particular calculation is a bit more complicated than you might imagine. So in this syndicated loan market, which is the dominant debt market on the loan side, the typical debt that is made available is floating rate debt. It's a term market. These corporate borrowers are typically lending for a number of years. 3 to 7 years is the most common term, but it could be running out to 25 years. It could be shorter than 3 years. But we're talking about a term loan market. But that term loan market is not one where you're charging interest at the same rate for the entire life of the loan. It's a floating rate market. It's a market where the borrower is paying an interest rate that reflects the cost of money in the market during the life of the loan, i.e. the underlying rate of interest changes. Interestingly, and again, it's beyond this lecture, but interestingly, of those two components that I mentioned earlier, the underlying market cost of money, originally LIBOR, was the bit that moved. The margin did not. It is typical, and it still is today, it's typical that even in the case of a term loan, the margin, the actual cost that you pass on to the borrower that reflects the credit risk in the deal, is fixed on day one, which is interesting. There are some interesting economic and legal issues that flow from that, which are beyond the lecture today, but that's something that we will definitely talk about at length if you join the course. But when I say the interest rate was a floating rate, it wasn't a rate that floated every day or every minute of the day. It floated periodically, and the most typical period in the international loan market is a quarter. So what this diagram is trying to show is a 5-year term loan that is divided up into yearly quarters. So each year there are 4 quarters. So 5 times 4 here, there are 20 quarters during the entire life of this loan. And the interest rate is reset at the end of each of these quarters. And when I say the interest rate is reset, the LIBOR interest rate. So we have a LIBOR reset at the end of each quarterly period, which means that the loan floats quarterly. If we can, so originally this was running for each quarter. You could get a LIBOR quote for each quarter. And so a borrower would know at the beginning of a quarter what the cost of interest would be at the end of that quarter, because it would be fixed at the beginning of that period. So it's a bit, it's not entirely correct to call this a true floating rate loan. It's a loan that is based on a series of underlying 3-month fixed rate loans. And that gave the borrowers a lot of certainty as to what their cost of funding would be for that 3-month period. If we can move on to the next diagram. please. That became, Rafa, if we could just move on to the next diagram, please.
1 second, it's not moving.
It's okay.
Yeah.
Yeah, perfect. Thank you. That changed as a consequence of the LIBOR scandal. So the LIBOR scandal blew during the global finance crisis. And again, the reasons for that we'll talk about in the course. But the regulators were no longer willing to support LIBOR because it had been manipulated by traders. And during the financial crisis, the interbank lending and borrowing market effectively came to an end. It froze because banks were not really prepared to lend to each other because they were concerned about the insolvency risk of doing that. So it was no longer possible to base the underlying LIBOR quotes on real transactions. The regulator was not prepared to stay with that. So we moved from LIBOR in 2021, 2022, all the changes were being introduced to a new regime that is called SONIA. This is a regime that just applies now to GB pounds. There are alternative benchmarks that apply to the US dollar, to the euro, etc., which we'll talk about in the course, but I'm just focusing on SONIA today. There are fundamental differences between SONIA and LIBOR. And one of the most important, which I'm trying to show in this diagram, is that SONIA is an overnight rate. It is an overnight sterling index. SONIA is quoted, and it's quoted overnight. You cannot get a SONIA quotation for 3 months, which you could for LIBOR, when the banks were going into the market and were giving quotations to originally the British Bankers Association and more recently to ICE, and those quotations were being published. Those quotations were 3-monthly quotations and they were fixed for 3 months. That is no longer possible because SONIA only operates as an overnight quotation. And what the market is trying to do, and what it has tried to do, is convert that overnight deposit structure into something that looks like LIBOR, because the market wanted to remain with that. And so what we have today is an interest rate mechanism that rolls overnight the SONIA quotations on a compounded basis, in order that at the end of the quarter, the borrower is in a position where they still have their quarterly interest payment that they have to make. What SONIA doesn't do is give them the ability to know with certainty what that payment is on day one. So what the market has done, and lawyers have effectively achieved this by adjusting the documentation, is by introducing a 5-day lag period, which is what the red dotted lines are intended to show here. So instead of the interest rate period starting on the day that the loan is drawn down, which is T in my example on the far left-hand side of that diagram as you're looking at it, the interest rate actually starts to accrue on T minus 5. And it does that so that it matures on the interest payment date minus 5. Again, if we go into the second of the 2 red dotted lines. And what that then gives, of course, is the borrower the ability to be informed what the interest payment is for that individual quarter. But they only know it 5 days before the end, not at the beginning. What this is trying to show you is the economics of moving from LIBOR to SONIA and how that is starting to impact how we structure debt instruments today. There's obviously a lot more complexity that I could talk about, but I'm trying to give you a sense of how the economics and the law play together, how they impact the way that these deals are structured, and how that really does, affect the way that business is transacted in the market. We can go on to the next slide, please. Keep going to the next diagram. Yeah, and this looks horribly complicated, and apologies, I'm not trying to present something to simply impress you with its complexity. This, believe it or not, is a very simple diagram showing the way that private equity typically structures their financing. And if we look down from the top, what it's trying to show is how the investors in the world of private equity, and these, as you probably know, are the sort of real investors who are normally called the limited partners. So these are the pension funds, the insurance companies, high net worth individuals who will be looking to invest in the world of private equity, together with the private equity platforms, the Blackstones, the Apollos, the CVCs of this world, these enormous financial conglomerates that are extremely dominant in the market today, how they actually acquire their underlying business. And what they typically do, they will go down through a number of companies in order to acquire the target companies that they're buying at the bottom of the structure. So if you look at this particular diagram, the companies that are being acquired by the private equity platform is the target company and typically a group of underlying subsidiaries. These are normally large groups that are being acquired with different operating companies within that particular group. But you'll see here that the company, the topco in my example, is not directly acquiring the target company at the bottom. Now, why is that? Well, it is primarily because the way that private equity operates is that it acquires these companies using what is called in the market leverage, debt. So the amount of equity that is used to acquire these companies is relatively modest by comparison with the amount of debt. And the debt that is acquired is also in different forms. And so what, again, this diagram is trying to show, there are three different types of debt here. There is the senior debt on the right-hand side of the diagram as you're looking at it, mezzanine debt on the left-hand side of the original borrower, and then high-yield debt, high-yield bonds that go in above that. Now, why are transactions structured in this way? Well, they're structured in this way because leverage creates value. We will talk about how that is achieved. We'll talk about the economics of that, the economics of how leverage creates value in the course. Now, having understood the way that leverage creates value from an economic perspective, we need then to understand how that is translated into transactions in order for them to work from a legal perspective. And the way that is achieved, again, economically, is by obtaining debt as cheaply as possible. And the debt that is available in these transactions, and there's just three here, this is a relatively simple transaction, believe it or not, each of the forms of debt that is made available to fund this acquisition will be priced differently. So the senior debt, as you might expect, at the bottom right-hand side, will be the cheapest debt in this structure. And the private equity house will obtain as much of that senior debt as they possibly can because that's the cheapest in the market. And they obviously will want to keep the overall cost of debt as cheap as possible. They will get as much of that debt as possible. And as soon as they've reached the cap of whatever that senior debt availability is, they'll move to the next bucket of debt. And for these purposes, let's assume that next bucket is mezzanine debt. They'll then obtain the most of that they can get. How much can they capitalize on that? They'll get that, and then they'll go finally to high yield bonds, which in the market at the moment is probably the most expensive debt and is typically the smallest component of the debt stack, but they'll have all three of those. Again, we'll talk about how that is achieved, why it is that by obtaining different types of debt, you obtain overall a cheaper cost of funding than would have been the case if you'd acquired all the debt from the same level, in this particular case, the senior debt. So why is it that by obtaining debt in different tranches, why is it that that achieves a low cost of funding? The legal part of this is then ensuring that this actually works from a legal perspective. And what is it that needs to work? Well, it is the tranching of the seniority of the debt. What we need to make sure is that the senior lenders who are taking the smallest risk because they're getting the smallest return, that's why their debt is cheapest, how is it that they are protected against the interests of the mezzanine lenders and the high yield bondholders? And there are two ways in which this is achieved in the market. Ultimately, we are subordinating the claims of the mezzanine lenders and the high yield bondholders to the senior lenders. And we are either doing that through contractual subordination, which is what we're doing as between the senior lenders and the mezzanine lenders. These two lenders are lending to the same borrower, and we have what is called an intercreditor agreement, which then effectively divides the interests of those two lenders by way of seniority, so that the senior lender is paid first and the mezzanine lender is paid second. That, as most of you will know if you're lawyers, that offends what is called the pari passu principle. We have a general principle of law that applies in most jurisdictions, which requires borrowers to treat their creditors in the same way. How is it that we structure these deals to avoid the application of the pari passu principle in a way that works from a legal perspective? And we'll talk about how that is achieved. The second way in which we can achieve subordination is through what we call structural subordination. So this is different. So senior lenders and mezzanine lenders are contractually subordinated. If we go up to the high yield bondholders, they are structurally subordinated, because the only way that the high yield bondholders can get paid from the subholding company is through dividend distributions that are pushed up through the structure from the original borrower to the subholding company. So the high yield bondholders will not have recourse at the level below the subholding company, i.e. the same level as the senior lenders and the mezzanine lenders. So we won't need to contractually subordinate them. They won't have a claim against the same borrower. Again, how do we achieve that legally? We'll talk through these issues in the course so you have a really good understanding of how this applies. And this structure, although, as I say, it's relatively simple, the features that I'm talking about are commonly applied in the financial and corporate markets today, and you will get a really good understanding of how that is applied when we talk through the course, both the economics course and the law course. And then two of the simulations that we look at will look precisely at these structures. If we can move on to the final diagram, please, wrap up. Thank you. What this is trying to show is how debt is structured in the market today and used holistically in all of these transactions. And I've run out of time now, so I'm going to keep this very, very short indeed. What I've been talking about so far is really down the left-hand side. So I've been talking about the distinction between different types of equity, preferred stock, common stock, going into the top of my structure, different forms of subordinated debt, so this could be the high yield bonds, the mezzanine financing, etc. That's in the blue box, and then the senior debt at the top, and you'll see the difference in the pricing, etc. But although that structure is often used in the market, we often see transactions where the debt is divided up into these different component parts, including the capital at the bottom, which is the equity. At the end of the day, debt and equity is all part of the capital of the business. The market has sort of moved almost on from that in some transactions, indeed in increasing numbers of transactions, where it blends the debt. Instead of the debt being divided between a senior debt piece and a junior debt piece, a mezzanine debt piece, for example, what we're often seeing is unitranche debt. So we're seeing one or a syndicate of banks going forward, making a single facility available to the borrower, and then tranching the debt behind the scenes, so the borrower is not party to this tranching, with other lenders. And so the pinky coloured box on the right-hand side of the transaction is trying to signify debt that is created that includes ultimately pricing for senior debt, for mezzanine debt, and for junior debt. And it's done behind the scenes. So again, we'll talk about the economics. We'll talk about how the unitranche debt is priced, what are the underlying economic drivers for the pricing, and how is that pricing then reflected in the underlying tranching that takes place within the facility itself. We'll look at the facility, we'll look at the clauses within the facility that make them work, we'll talk about the legal issues, and then we'll talk about transactions in which unitranche facilities are used. I think that's probably enough for me, Anu. Can I hand over now to one of my colleagues, Anu, who administers the day-to-day running of the MLF, and we'll talk about the application process and other issues.
Mm-hmm.
Thank you, Anu.
Thank you very much, Graham. Raphael, do we still have the slides? Great, thank you. So I'll just take you through the admissions process, and then Graham and I can answer some of your questions. Could we go to the slides down? Perfect, thank you so much. So our program is a 12-month course, and applications are currently open for entry in September 2026. In your application, you should submit your academic transcripts, a personal statement, and 2 references. One of it should be an academic reference if you studied recently. I would also recommend submitting your CV if you have one. You can visit our prospectus for the application link and instructions. Applications on our program are considered on a rolling basis, which means that we may close earlier if the program reaches capacity. So for that reason, we would generally recommend applying as soon as you're able to. Once you submit an application, you may expect to receive a decision within about 10 weeks of receiving both references. Could we get the next slide, please? Thank you. So the minimum entry requirement for the program is a high 2-1, which is equivalent to the average of 68% across all years of study. So we accept students with either a background in law or a background in finance, economics, accounting, business administration, or cognate discipline. You'll have the opportunity to prepare well for interdisciplinary study through pre-sessionals in both law and finance over the summer before the main program begins. We anticipate that most of our applicants will have met the academic criteria, but we may also consider applicants who are close to but who have not met the threshold. For example, students with highly relevant professional experience. For the language requirements, we require level 4 English for a Faculty of Laws, which can be fulfilled in the ways listed there. If you're curious to know whether or not you need to take an English language test, or if you're curious to know what the equivalent of 68% is in your jurisdiction, you're very welcome to get in touch with me by email at any time. To ensure the best experience with a high staff to student ratio, we anticipate a cohort of around 50 students. So that means that there's no automatic criteria for admissions decisions, and each application is holistically assessed by our subject expert professors, such as Graham. So this does mean that you can position yourself well by really using the personal statement to highlight your interest in the program or anything that kind of goes beyond your academic transcript. If we go to the next page, so if you are interested in securing funding for your studies, we recommend that you start to look now for any opportunities that you might be eligible for, since some scholarship deadlines have already passed, such as the Chevening and Commonwealth scholarships. At UCL, we offer a master's scholarship for both international and home domiciled students, with application deadlines in May and June of next year. But on our program specifically, we're also pleased to offer a fully funded scholarship consisting of both fees and a stipend. And this is specifically for students who have been and are of limited means. There's no geographic restrictions for the scholarship, but students must meet the financial criteria, and they can't have already obtained a master's degree. The deadline to apply for the scholarship is the 20th of March. We have a very limited number of scholarships against a high volume of applications, so the process is competitive, and we would generally recommend that you apply for other scholarships as well. You can take a look at the Central UCL scholarships and funding pages, which have a lot of information about the different scholarships that you might be eligible for. And then the next page, thank you. So if you have any questions, you're very welcome to send us an email at mlf-admissions@ucl.ac.uk. The best place to look for information about the program is our faculty website, which is linked there. But you can also book a one-to-one consultation with me to discuss your specific interests. I think we can open the floor up to questions now. So please feel free to use the Q&A to ask anything you might be interested in. We had some questions that came in by, sorry, I think we can probably keep the previous slide just for attendees. Thanks. We had some questions coming in by email, and Graham, I wondered if you could help me answer some of them.
Yeah, of course. There's an interesting one. What professional prospects await me after the program? How can this degree enrich my career? Hopefully, my short presentation gave you a sense of that. This will be such a groundbreaking degree, and I can't emphasize enough what a difference it will make having professionals who understand both the underlying economic drivers, the legal drivers, which is a lot, but actually then combining them, understanding how they interrelate and what that actually means in terms of transactions in the market. That is almost unique. When we've been in discussions with prospective employers, i.e. the people that we've lined up to deliver the placements and the deal simulations, they have been hugely impressed at the prospect of taking students. It's not surprising, but I have absolutely no doubt that it will significantly enhance your career prospects if you're looking to join, a large global international law firm, a large global international finance firm, investment banks, private equity houses, corporate restructuring, advisory agencies, etc. Significant difference. What are my prospects by enrolling onto the degree? If I've already pursued an LLB, I've got a keen interest in finance and wish to broaden my horizons in this area of work. Well, if that's who you are, this is the perfect degree for you. You will continue to hone your legal skills. There's a significant part of the course that is focusing on, continuing to do that, developing them further, honing them in terms of your analytical skills. You'll obviously get an understanding, again, a detailed understanding of the underlying theory of some of the economic principles that are relevant in the corporate and finance markets. But again, forgive me, I'm repeating myself, but it's really important. The really key thing here is then the intersection of those underlying theories and applying it in practice. So it'll be transformative. I think you've covered the other questions in your presentation, Anna.
Great, thank you so much. We have a few questions by in the Q&A as well, if you wouldn't mind. So one of the questions is the program suitable for a corporate lawyer who's more interested in the policy and governance aspects of finance, or is it calculations focused?
It's not just to be clear, it's not calculations focused. You're not going to be sitting and just working on the underlying models. So, I mean, a good example that would respond to your question would be regulation, which I didn't really have a chance to touch upon. So looking at underlying regulatory developments, how they apply, regulatory developments in relation to corporate governance, for example, would be a good example of that. ESG, might be an even better example. But instead of just talking about ESG and how ESG might impact corporate governance decisions, we're going to look at the underlying principles that drive ESG. So it's much more thoughtful. What is it about ESG? I mean, ESG ratchets, for example, in relation to financing. ESG ratchets in relation to the business plan that relates to the private equity target. So it's a more holistic approach to those issues.
Great, thank you. We also have another career-focused question. So someone is asking, as a project finance attorney who also works on international development finance, does this program also appear relevant to my career prospects? Absolutely.
It is not going to focus purely on project finance. I'm not going to pretend that at all, but it will focus. This is about capital. So it is focusing on equity and debt in the context of the international corporate markets today. So, how do corporates generate? How do they generate capital? Where does the capital come from? What does it look like? what are the implications of what it looks like, what are the economic drivers, what are the legal drivers. So, we'll be looking at structured debt, for example. So, one of the ways in which project finance is applied in the market today, as you know, is within the capital markets. So many projects are financed through the capital markets through forms of securitization, for example. We'll look at those in detail. So the underlying principles that underpin project finance we will be looking at, but we'll be thinking about those issues in a slightly different way than you might have thought about them if you just studied as a lawyer.
That's great. Thank you so much, Graham. We have a couple of questions about the experiential learning pathways. One of which is the selection of candidates for work placements by grades or other criteria, or do students apply directly to the institutions? Another question is, what criteria does the program use to allocate students to the placement pathway? And what point in the course do you get to know which pathway you've undertaken?
I'll try to respond to all of those. And Maria will help me because she's running the process at the moment. We are in the process of We're in the process of selecting at the moment. So you don't apply. Well, you do apply directly, but you apply through a coordinated process, which Maria and other members of the team oversee. We're looking to match people with the appropriate expertise with the placement counterparty. And I should say that the placement is not guaranteed. It's a competitive process, and there is criteria that apply in each particular case. So the placement counterparties are looking for people with a particular skill set. In some cases, there are others where there's a fairly loose. But what we're looking to do is match people to those opportunities, not just one. So what we're typically doing is looking to identify 2 or 3 people, if indeed we have 2 or 3 people applying to each of the placement counterparties, to apply for each one, and then put those CVs and applications to the relevant placement counterparty for them to take a decision. All of the placement counterparties that we have arrangements with obviously want to make their own selection ultimately, but we're making the proposals to them based on the conversations we've had about their criteria. Marie, I don't know if you want to add anything to that.
Yes, everything you said is correct. I think it's important to point out every student that wants to apply for placement can do so. All the applications are done through UCL, and it is a guided process where we limit the amount of placements you can apply to, as well as it will be shortlisted by UCL staff. However, the final decisions on who to invite for interviews and who placements will be offered to are made by the placement partners themselves. So essentially, it is a recruitment process with the aim of getting most of our students the most suitable placements. The deal simulations are open to all students. So anybody who decides to apply for placements will be able to do the deal simulations in case they're not successful. I think that is important to know.
It is, but we should also make, I feel quite strongly about this, the deal simulations are not a second choice.
No, they're not.
And in fact, I could easily argue that the deal simulations are more appropriate because they're more bespoke. We have built the deal simulations to fit the program perfectly, and they will reflect what you have been taught. But just to be clear, we can't do that for the placements, because the placements, it will be a question of you then working on whatever the firm is working on when you join them. And that might be one transaction, it might be 10 transactions, it might be a mixture of the two. I mean, in some cases, you might get an experience in 2 departments, but in most of the placements, you're getting an experience of one particular type of work, and possibly even just one transaction. Now, I'm not saying that's a bad thing, it's different. So, but I don't want people thinking that the deal simulations are a second choice, a second best, because they're not.
They're absolutely not. And we have started the process by asking students whether they want to deal simulations or if they want to apply for placements.
Yeah.
the deal simulations also from a career point of view, this year's students will be working with 4 different top-tier law firms on this. This is a massive, great thing to add to your CV and your experience for either cover letters or interview questions. So they're in no way, from a careers point of view, a second choice. But there is a placement process that you apply through the university. And our goal is to get everybody the best possible experience and education.
Yep. Any other questions in there?
I just have a few more questions. So another question on the placements is, how often do firms convert placements into full-time job offers? If so, what are the typical pathways?
Yeah, no, that's a very good question. Thank you. There is no guarantee at all of a job following the placement. Just to be clear, the placement is part of the program. It's not a pathway immediately into a job. Now, so that's the answer to your question. Now, clearly, if you get a placement with a leading firm and you impress during that placement, who knows? I would be very surprised indeed if that might not lead to something, but there's absolutely no guarantee of that.
Thank you for answering. Another question is whether there's any information from the previous cohort class profile. I think I could probably answer that. So we have a mix of students across different disciplines. So we have students with a background in law, we have students with a background in finance, we have students with a background in economics. The cohort, as I said, is limited to size of around 50, just to facilitate, high staff student interaction. Graham, I just had one more question for you, which is quite specific. Someone is asking, so LIBOR contained a built-in term bank credit premium, whereas SONIA, as an overnight transaction-based rate, largely strips this out. How has the removal of this credit sensitivity affected the economics of syndicated bank loans, particularly in terms of lender compensation for risk?
Oh, that's a great question. I hope you're going to come on the course. You're talking about credit adjustment spread, CAS. If I had 3 hours to talk to you about this, we'd have a great conversation. You're absolutely right. The fact that the deposits are placed overnight means that there really isn't any credit risk when someone is placing that deposit overnight, whereas in the past, when someone was giving a quote for 3 months, placing a deposit with another bank for 3 months does have a credit risk attaching to it, obviously the 3 months. So the SONIA quotation does not include that credit risk element. You're absolutely right. And because we're trying to make SONIA look like LIBOR, there's been something added to the SONIA calculation to reflect that, and it's called CAS, C-A-S, a credit adjustment spread. So this is another feature that we'll talk about in the course. We'll be talking about the additional changes, the way in which SONIA has been adjusted to convert it from an overnight rate into something that looks a bit more, well, probably a lot more like the term rate, i.e. LIBOR. I personally don't think it gets there perfectly. I think, what we've done to get it to where it is has addressed some of the issues, but not everything. We'll be talking about what those are and what the consequences of that are as well. So, that credit adjustment spread issue, does that compensate the lenders fully for what that credit risk would otherwise be? In some cases, they might argue it does. In other cases, it might not. And what are the consequences of that? Anyway, a great question, and apologies, I wasn't able to go through all of those issues when I was talking, but I went on far too long as it was, so I'm sure you understand why.
That's great. Thank you so much, Graham. That was actually the last question that we had. So just wanted to thank you all so much for joining us today. We hope the session has given you a sense of what the program is and what it offers. If you have any questions that we didn't get around to, or if you need guidance on specific circumstances, please feel free to send me an email at mlf-admissions, or you can book a meeting with me. Thank you so much also to Graham and Marie and Raphael. I hope you all have a good weekend ahead.
Right. Thank you.
Okay. Thank you so much.
Anna.